Okay, we are now starting. For those of you standing, please sit. Our next presentation is going to come from Justice Maria Kawimbe, who is going to make a presentation on judicial perspective on trial advocacy in electoral offenses. As per our court decorum, it is not anticipated that we'll be moving about as the judge takes the podium. So please, let's ensure we sit and allow the presenter to make the presentation. In the same vein, I wish to announce that there'll be a little adjustment in our program in order to catch up with the remaining sessions. As we proceed, you note the adjustment that will be made. In the meantime, I'd like to call upon the dance group to give us one song. Thank you very much. Thank you very much. We will now proceed to have the presentations done now that we are done with the opening ceremony. But before we do that, I would like to acknowledge the presence of our delegate from Angola, Mr. Matos Dias. Ah, bon dia, bon dia. Excellent, excellent. You're welcome. You're welcome. IT, ladies and gentlemen, allow me to introduce our first presenter for the day, and this is none other than Honorable Justice Maria Mapani Kawimbe. But before she comes to the podium, let's have the introduction.
Zambia's highest court, she stood where you stand, a prosecutor in the trenches fighting, learning that justice isn't argued, it's earned. But she didn't stop at the courtroom door. She shaped policy at the highest levels, gave voice across an entire continent. For 5 years, she led the fight for Africa's most vulnerable children. Vice chairperson, deputy rapporteur, special rapporteur for children without parents, a title that doesn't just sit on paper. It means she fought for those the world forgets. Today, she guards something even bigger. She advises the Chief Justice on elections. She protects the integrity of every vote, the most sensitive task in any democracy. And now, she sits on the Constitutional Court, the final voice on the supreme law of the land. She started where you are, prosecutor, advocate, fighter. She became where few ever reach. Ladies and gentlemen, please welcome Lady Justice Maria Mapani Kawimbe.
Mo- Good morning again, and thank you so much for your warm embrace. I do not take it lightly. And standing here and looking at the room, it really becomes real for me that this is what a ward in a constituency looks like. And if there was an election petition, you'd be the ones who had voted, and you'd be the ones through your representative who would come now to court to challenge the outcome of that election. What I see now in front of me is what an election petition at the local government level, perhaps, or a ward within a constituency would look like. But what is more important for me is that I am one of you. I have been where you sit, and if the years had rolled back, I probably would have been one of the participants in the meeting. So I'm very grateful for this opportunity to speak to you, and also start by bringing you warm greetings from the Honorable Chief Justice of Zambia, Dr. Mumba Malila, who has asked me to be with you today. The Director of Public Prosecutions, and all protocol observed. We unite today in a common and paramount purpose to champion electoral justice, which is an ever-growing imperative on how it serves as a fundamental pillar of the democratic edifice. Electoral justice, and consequently an effective electoral dispute resolution mechanism, also serves as a crucial bridge between the electoral process on one hand and the credibility of elections. That is to say, an election does not end when the last vote is cast, but rather is fortified when disputes are resolved justly, efficiently, and in a manner that commands public respect. I have been asked today to give reflections on judicial perspective on trial advocacy in electoral offenses. However, before I do so, I find it necessary to lay out the architecture of our electoral dispute resolution mechanism. Slides. So the architecture of an electoral dispute resolution system is established in the Constitution of Zambia and the Electoral Process Act. The preamble of the Constitution sets the tone by announcing our commitment to virtues of upholding principles of democracy and good governance, the equal worth of women and men to freely participate in building a sustainable political order, and the rule of law as foundational values. Why does electoral justice matter? It matters because it is a way of ensuring political stability. The slide. The slide. It is a way of ensuring political stability, government legitimacy, accountability of leaders, non-violent political competition. How do you do this? If you can go back, I'll do that. Yes. How is this done? Let's go back to the slide before. The one on why electoral justice matters. The second slide. If you can take me to the beginning of the presentation. Yes. The second, go again. Next one. Yes. What I want to emphasize here is the point about government legitimacy and political stability. Why do we vote? And that's the question we are asking ourselves today. Why do we vote? And why should our vote count? What makes this so fundamental in electoral justice? It means that where the vote is not credible, it may lead to political instability and an illegitimate government. So one of the ways in which we ensure that after voting, our vote really counts and that the person who will represent us in parliament or local government is the person, or as president, is the person that we want to do so, must be held accountable. And this is only done through the courts, determining whether the electoral victory was earned or not. Now, to be effective, and when I talk about the EDR mechanism, which is the electoral dispute resolution mechanism, I am talking about courts, I'm talking about the Attorney General's office, I'm talking about the DPP's office and other actors who are involved, and especially the police who are involved in ensuring that we have a credible EDR mechanism. How does this come about? Firstly, by ensuring that there are robust laws upholding a system of free and fair elections. Next slide. The architecture for our EDR mechanism exists through the Constitution of Zambia, Amendment Act number 2 of 2016, which introduced the following changes. Firstly, it established the Constitutional Court as a specialized court. It also introduced, the next slide, introduced strict time frames for hearing of presidential. Next slide, please. Introduced strict time frames for the hearing of presidential, parliamentary, and local government elections. One of the famous cases in which the Constitutional Court pronounced itself on strict time frames for hearing elections is the case of Electoral Commission of Zambia versus Belemu Sibanze and Bernard Kanengo versus Attorney General. In this case, maybe perhaps more relevantly, the Electoral Commission of Zambia in Belemu was sued because Belemu committed electoral fraud, and he was convicted by the magistrates court, and then after that his seat was declared vacant. But when the matter came to court and the Constitutional Court, he raised a ground that his election had not, rather the nullification of his election result had not been properly conducted, because what should have happened was that the local government election tribunal should have been constituted by the Chief Justice, and thereafter annulled. I mean, heard his case, determined it, and then pronounced that he had been invalidly elected. But in that case, we held that because what then came was that a by-election was announced by Electoral Commission of Zambia, and he wanted us to stop that process by the ECZ. But when he came to court, we said that the timelines set in the Constitution for conducting presidential, parliamentary, or local government elections is set. And because the time is set by the Constitution, it cannot be extended by the court. I also say in terms of the 2016 Constitution that it introduced a multi-layered EDRM mechanism whose hierarchy is as follows. Firstly, the Constitutional Court, which only deals with presidential election petitions, election appeals from the high courts and local government election tribunals. No nomination petition challenges will lie to this court from either parliamentary or local government election tribunals. The High Court deals exclusively with parliamentary election petitions, and no petitions lie from the High Court from local government elections. Local government election tribunals, LGETs, deal with election disputes at that level and are presided over by the magistrate and legal practitioners. Here, I must pause to say that, except for the requirement that the presiding officer should be a magistrate, legal practitioners, including yourselves from the National Prosecution Authority, or other prosecutors are free to sit on these LGETs once they are constituted. In fact, I would encourage the Director of Public Prosecutions to offer to the Chief Justice that some of the advocates from the NPA should sit on these local government election tribunals for the August 2026 elections. The Supreme Court and the Court of Appeal have no jurisdiction over nomination or election petition appeals. This arises from the case of, I think that was Bowman and Malangi versus the Attorney General, where an interlocutory application arose before the High Court, which was handling a parliamentary election petition in that case. And when it came to the Constitutional Court, we clarified that under the 2016 Constitution, the Supreme Court and Court of Appeals have no jurisdiction over nomination or election petition appeals, or indeed other election-related cases. The legal framework governing elections, as I've stated, is the Constitution of Zambia, and in particular, here I would like to draw your attention to Act number 13 of 2025, which introduced the new Article 27, in which now the electoral system in the country has changed to include a mixed member proportional representative electoral system. We have the Electoral Process Act, the Constitutional Court Act, the Electoral Commission of Zambia Act, High Court Act, the Interpretation and General Provisions Act, Chapter 12, the Laws of Zambia, the Local Government Act, the Constitutional Court Rules, the High Court Rules, the Electoral Petition Rules, the Local Government Elections Tribunals Rules, the Electoral Process General Regulation Statutory Instrument of 2016, and Judicial Precedent. On Judicial Precedent, these are the judgments that the court is pronouncing itself based on the 2016 electoral provisions. Now, in terms of Section 97 of the Electoral Process Act, an election for a member of parliament or councillor, which is different from a presidential election, can only be nullified if the corrupt practice or alleged illegal act occurred, where there is non-compliance with the electoral law affecting the result of the election, and if the candidate at the time of the election was not qualified to stand. Here, I would really like to say, and I'm grateful that the Anti-Corruption Commission is presented, because there are a lot of allegations in most election petitions which point to corrupt practices or illegal acts which occur during pre-election disputes, mostly. Maybe let me just say that here, that in terms of the role of the director of, rather the National Prosecution Authority, because I sat in quite a number of election petitions in the High Court, most of the allegations that would come regarded violence, corruption, bribery, and illegal practices. Now, here the point I want to make is that courts have no jurisdiction in pre-election disputes. Courts only have jurisdiction in nomination and election petitions. But most of the things that happen in the pre-election season, where all these acts of vote buying, bribery, corruption, violence are happening, are things that will then come out in the election petitions. Up to now, there has been no real vigilance to prosecute these offenses. What the ECZ has, and part of its mandate under its act, is to prosecute minor election offenses and to deal with all pre-election disputes. But then the question and the gap lies that what happens to all these illegal acts or all these electoral acts of violence that happen and are not prosecuted by the DPP? So this is something that I hope at the end of the workshop you would be looking at, so that these matters are not just a question where the courts void an election, but do not go further to hold the people who commit these transgressions personally accountable. Having said that, an election will be voided, the next slide, where a candidate had no knowledge of the offense, rather, will not be declared void, where a candidate says that they had no knowledge of the offense, or that the offense were committed without their consent, or reasonable steps were taken to prevent the commission of the offenses. Elections substantially, that the election was substantially free from corrupt practices. Here, the point I want to emphasize is that a candidate will never accept that he had knowledge or no knowledge of the offense. When in actual fact, it could be that he was actually the one who these offenses were committed with his full consent. So now the thing comes here for investigators to prosecute, to investigate cases very effectively, so that when they're presented before the DPP, prosecution can follow. So far, and I stand corrected, I do not think that there's any case where a person has been personally held liable for electoral violence. I know that we have nullified 2 elections, and even when we did that, the victory or the reward for the loser was that the election of the person who was alleged to have committed the electoral offenses was nullified and nothing moved. When we move to the burden and standard of proof in election matters, it is important to state that it lies with the petitioner to prove the electoral offense complained of. Next slide. And that the standard is higher in election petitions, or election petitions higher than the balance of probabilities, but lower than beyond reasonable doubt. So the standard here is that election petition grievances must be established to a fairly degree of convincing clarity. This is standard was set out in the cases that are highlighted there, but to still show that when it comes to criminal liability, the standard will remain higher than what would exist even in an election petition, which has a slightly raised standard than an ordinary civil matter. In 2016 and the 2021 EDR cycles, the court and the local government tribunals were dealing with election petitions under a new constitution. So following from that, there were quite a number of challenges that arose. The initial ones were that the application of the new electoral laws created challenges for both courts and tribunals. Also, there was no jurisprudence upon which adjudicators in the High Court and local governments could base their decisions on. So there were a lot of conflicting decisions that came up on appeal, and most of them were reversed. However, in 2016, the trend changed because now was jurisprudence from the court, and the lower benches were well guided on what to do. However, there was a um, lack of rules of procedure still for the High Court in electoral matters, in the sense that now we still rely on the electoral rules of 1968, which are not in touch with the modern needs of an adjudicative body exercising electoral jurisdiction. As a result, this ignited an impetus for change within the judiciary to see where we had a lot of gaps, and we still do because we're working on them. But what the Chief Justice did, learning from the past EDR cycles and from the experiences that we went through, informed by our mistakes or learning experiences, the Chief Justice established an advisory committee on election management, which I chair since 2023. The Chief Justice's advisory committee on elections main purpose is to drive the much needed and urgent reforms in promoting an effective EDR mechanism. Our acronym is known as ASIM. ASIM is one of the only two committees in Africa, other than Kenya, which is dedicated to judicial electoral reform. It's mandated to drive reforms in electoral dispute resolution. And among that, our key strides in EDR have been to review and formulate, next slide, court rules across the 3 tiers of the EDR. The next slide. The purpose is to improve and strengthen the legal framework in which election-related disputes are handled and settled. By so doing, we want to improve efficiency and clarity in electoral dispute adjudication, strengthen the legal framework governing electoral disputes. As part of our key disputes on the next slide, what we have done is to develop a specialized handbook or bench book on EDR for adjudicators, also to create materials to equip adjudicators with clear guidance on navigating the unique challenges of pre-electoral, polling day, and post-electoral dispute resolution. We have also finalized frequently asked questions documents to demystify EDR. In these documents, what we intend to do is to explain how petitions work, court operations, citizens' rights in an effort to promote transparency and public trust in the operations of the judiciary. Now, turning to the topic that has brought me here, which is the judicial perspective on trial advocacy in electoral offenses. I thought I'd give you that background to show you what the whole system of EDR looks like, and then now come to your role as prosecutors. Your role in EDR is that you are generally expected not only to enforce the law, but to be part of the system that protects the constitutional order that I have talked about. Meaning that you are sentinels, and as the workshop theme is rightfully titled, being sentinels, have a duty emanating from the Constitution to defend and protect it, and in so doing to ensure that all electoral offenses are prosecuted with vigor and to the letter of the law. From a judicial perspective, our reflection on prosecutors will be on how they conduct their advocacy, trial advocacy, when dealing with electoral offenses, because this serves as a litmus test in determining whether justice succeeds or fails. I'll explain that a little later and why. So it begins with case preparation. And here, let me say that I am already preaching to the converted. You know your job, you know how to prepare cases, and you know how to present them in court. But these perspectives I share are from the experience of the bench. And one of the things that is cardinal in your work is to ensure that when you are preparing for the case, because this is the foundation of a successful prosecution, that you will do it very diligently. So, electoral offenses, how do we see them? In Zambia, we as adjudicators or judges approach electoral offense cases with heightened sensitivity. Why? Because elections are constitutionally protected process. As I said, it's in the Constitution. You cannot have any shortcuts on a constitutionally protected process because all subsidiary legislation that would guide you derives from the Constitution. So we have to pay particular attention to the spirit and law in the Constitution because anything that we do that is beneath a constitutional standard will amount to a violation of anyone's rights. Electoral offenses also undermine public confidence in governance. What do I mean by this? When electoral offenses occur, and if those who are tasked with the responsibility to prosecute them turn a blind eye, the public views you differently. It views you differently because they think that depending on the divide, whether it looks pro-government, then people will come to the conclusion that you are failing to do this because you have taken this stance. And because of that, you introduce an element of bias. And that is easily discernible from the bench. Prosecutions also occur in politically charged environments. And because of that, there is a danger that prosecutors might want to play to the gallery. And when you're coming to court, you're grandstanding when prosecuting the offenses, when what you should honestly be doing is just looking at what the law provides, preparing a good case that when it comes to court, depending on what the law says, it may succeed or not succeed. Yours is not to be consumed by public opinion. Yours is to prosecute cases based on the law, irrespective of the political environment. Electoral offenses under the Electoral Process Act are not minor electoral breaches, but serious in nature. And why do I say this? If you look at the Electoral Process Act, where the Electoral Code of Conduct sits as a schedule, it lists very serious offenses. These include impersonation, bribery, undue influence, electoral violence, misuse of public resources, hate speech, breach of Electoral Code of Conduct, and etc. When you look at these offenses, these are very serious offenses against the person, and it bears on the prosecutor. This has an impact on how the election is conducted, the integrity and credibility of the process. Because when an election is free from offenses, and offenses are serious of this nature, then it is more likely to be credible. But if the reverse is, and if prosecutors do not step in and through thorough investigations from the investigative wings, being the Zambia police and all these other agencies, you have a bigger obligation to ensure that when cases are reported, dockets are prepared, time is sent to the DPP. When National Prosecution Authority appears in court, they should be well prepared and have their witnesses, because these things are affecting the outcome of the election. So there must be some urgency to ensure that they are prosecuted on time. The burden of proof in the prosecution of electoral offenses, which are criminal in nature, rests on the prosecution to prove a case. So the burden doesn't shift because now this is an electoral offense. As for the standard, what this means, that is, beyond all reasonable doubt from the bench's side, is that prosecutors' cases must be well prepared. There must be a higher scrutiny of evidence before taking the decision to prosecute. Don't prosecute because the public opinion is forcing you, or don't prosecute because you hate someone, or don't prosecute because you want a desired result. Make sure that you have studied the evidence before taking the decision to prosecute. There should be zero tolerance to procedural shortcuts. Let's not prepare cases hastily, because when they come to court, the high chances of them being unsuccessful are always high, because you rush the procedure, you tried to please an audience, you tried to grandstand, and at the end of the day, the court will throw out the case. So there should be, in the end, strict adherence to substantive and procedural law, legality, and fairness. How you treat a person who has been accused of a crime, fairness is imperative. It doesn't water down because of the person involved. Be fair in the work that you do. What works in court? When we see that there's a precise charge that has been brought before court, correct citation of statutory provisions, because this alone can lead to a case to be thrown out of court. There should be clear articulation of elements of the offense, charges aligned with the evidence available. Avoid this thing of duplicity of charges. Just be specific. Bring the case because this is what you are looking for. Do not bring a case because you just want to show the world how many charges you can lay against a person, because the chances are it will be badly prosecuted and it will eventually lead to an acquittal. Not because the conduct was lawful, but because the prosecution was defective, and you lose a lot of cases. Properly authenticate evidence. I can't say this more. Don't come to court with evidence that is not well authenticated. And also, another thing is on competent witnesses. Don't bring 30 witnesses to say the same thing and maybe even say nothing at all. And maybe if I let you in a little secret, when you see a judge has stopped writing, it's because now they are tired. You are forcing a point which is not helpful to your case. So if two good witnesses can prove your case, do it. Don't bring 30 counts. And in all those 30 counts, nothing new is coming out of those. So let's take this very seriously. And also on the clear chain of custody of evidence. This is a problem perhaps which needs to be addressed in collaboration with the police on the chain of custody because of evidence. Because sometimes when the evidence comes, and even when the prosecution has a good case, it might just be lost on that because of the way evidence was handled. Now, I just want to say perhaps a little on as an illustration of section 83A of the EPA, which is on the next slide. I won't go into this because Mr. Musenga is here and he presents immediately after me, and you'll go more into the electoral offenses. But I thought by way of illustration that I should perhaps speak on section 83 of the EPA. So section 83 of the Electoral Process Act broadly prescribes undue influence, which is any threat or act that interferes with free exercise of voters' rights. Now, when you're looking at this offense, what you will be actually looking at is the threat of physical violence or spiritual injury, because that's what the section says, abduction, intimidation, or any use of force qualifies. That's what section 83 provides. So the target of the threats or acts need not be the electorate, as preventing officials of the ECZ from carrying out their function of election management. It could be that. And there are three categories of offenses covered under section 83 of the Act of the EPA. These offenses are of strict liability. The prohibited conduct is the only constituent element of the offense without attendant mental culpability. Reasons for this lies in the fact that force, violence, restraint, and infliction of harm or threats of any of these direct threats to conduct of free and fair elections is very important. Therefore, mere conduct without any mental fault, just the mere conduct, is criminalized under Section 83. Section 83 aims to prohibit certain acts. Again, here I talk about them in a little bit more detail. So it prohibits any act or threatened violence with the effect of inducing or compelling a voter to engage or not engage in an election-related activity. Specific election activities, including voter registration, actual vote in support of a political party or candidate, or participation in any political party. The phrase do or threaten to do something to the disadvantage of any person suggests that the prohibited conduct under this offense is quite wide and could include any form of actual or threatened injury to a person. For a conviction to be secured, and this is where it matters for you, the prohibited act has to be accompanied by an intention of achieving specific voter behavior. So where you're threatening voters, you're threatening them because you want them to vote in a particular direction. And when you achieve that, then you'll be achieving that specific voter behavior that you are looking for. So when you're prosecuting cases under Section 83, you may want to look at those things. This category also includes undue influence, which includes prescribed acts under Section 83(6) of preventing or impeding the free exercise of a vote by a voter through acts of abduction, fraud, or duress. From here, you can see for yourselves how you'd prepare your case, because there are quite a number of elements to be considered. But paying attention to what is important to be proved in this particular section that I have cited. We also have Section 83(2) of the EPA, which prohibits prevention of the exercise of any right conferred by the EPA. This is another offense falling under the category of undue influence. So you can see that undue influence has a lot of elements under it. And all these affect how a person is going to vote in the election. The exercise of functions of the ECZ, I'm sorry, didn't come out correctly, but saying that there's interference where you interfere with the independence and impartiality of the Electoral Commission of Zambia, that is also prohibited. And where the ECZ, because the ECZ could be the complainant and report this matter to the police. So the National Prosecution Authority also has a role to protect the office of the Electoral Commission of Zambia. So mental culpability, if I may emphasize, is implicit in the category of three offenses, seen as offenses presuppose the knowledge that a particular individual or an employee of an agent of the ECZ and carries out an official function. Further, the deliberate acts of interference, reward, or prejudice also point to the mental element. So I've been talking about mental conduct and mental element. And this is just an illustration. I would really, if we had more time, then we would sit down and go into these elements in a more interactive way. But unfortunately, I am just giving an overview. The next presenter will say a bit more about these electoral offenses. But in terms of general defenses, a person could come and say that I did not have intention to unduly influence the voter. I did it, but I didn't know that it would result into this. Or a voter acted voluntarily and was not compelled to act in a particular way. Those are some of the defenses that would come. And that is what I said earlier on, that in some of these things, the person who is saying, and this is a candidate who does not have knowledge or consent of these offenses, would actually be the one driving them. So how do you prove this lack of intent or that a voter acted voluntarily when you're prosecuting these cases? In the case of Mutantika and Shiel versus Chipungu and Electoral Commission of Zambia, which I cite there and thankfully came before the High Court, it was held that for a threat to amount to undue influence, the High Court now determining what amounts to undue influence, it should have an effect on the person threatened. So it follows that from this that an accused person can argue that though having threatened to use force or violence, the threat did not have any effect on the persons threatened. So what you'd be looking at in proving some of these allegations or some of these accusations is the threat, whether this threat amounts to someone being actually threatened. And this is something that in careful case preparation would come out. So although Zambia has an elaborate legislative provision aimed at combating a wide range of electoral violence and intimidation, it appears to lack enforcement of these provisions. That's what I drive at, because I don't know if it's a question of investigation or not, or cases being investigated and the DPP not taking action, or ECZ settling these cases through mediation and conciliation and ignoring the larger element that any person who commits a criminal offense should be held responsible. So once the ingredients of the expansive, offensive, and due influence as set out above are that a prosecutor faced a case involving electoral violence should be well able to contextualize the offense of undue influence properly. That's the point I have been making. Now, from the judicial perspective of what we expect of prosecutors, we expect you to exercise independence. And the DPP talked about independence earlier on. He actually said that without independence, and I hope I'm quoting him properly, that the prosecutors cannot effectively discharge their functions. So how are you perceived then, or how are you seen from a judicial perspective to be independent? You must be politically neutral. Avoid being heavy-handed, because sometimes you're heavy-handed across certain parties. And also let your prosecutions only be driven by evidence. This principle was underscored in the case of Anderson, Mazoka, and others versus Levy Patrick Mwanawasa, when the Supreme Court said that the principle that courts should only decide, and this falls on courts eventually, that when you come to court, the only consideration we should take in deciding electoral disputes or electoral related disputes is only to be based on the law and evidence, and not any other considerations such as political narratives. From our expectations as judges, we expect you also to exercise a lot of professional restraint. Act as ministers of justice, not political combatants. You are sentinels. That's a constitutional duty that you bear. And don't take this lightly. In so doing, you must decline weak or speculative cases, avoid inflammatory language in court, and respect, most importantly, respect the accused's rights, because he or she is entitled to a fair trial. In short, an overzealous prosecution may satisfy public emotion, but fail judicial scrutiny. And how do you fail this? When your case is thrown out. Technical competence. We also expect that of you. Master the electoral statutes. In so doing, common judicial concerns, when you have not done this, shows through wrongly framed charges of failure to prove statutory elements. What's the takeaway? If an offense is statutory, it must be proved exactly as defined, not as morally understood. Don't bring what you think morally to be a case. Bring a case that is based on the law, and only the law. And the rest, the law will do through implementation by judges. Prosecutors have a duty to objectively assess all evidence reviewed by investigators to satisfy themselves that there's a real prospect of conviction. Do not accept everything that is brought at face value by the police. Interrogate it. And from there, decide whether you are going to prosecute the case, but alive also remain alive to witness protection measures, because in election cases, most where there's violence, it's really high, and there must be a way of protecting witnesses, because if you don't, they will not come to court, even when you have prepared very good cases. So find a way in which you can protect witnesses, and this could also be through holding cases in camera, and also safeguarding the well-being of witnesses when they're in court or after they leave court. Because if you do not do this and electoral violence perpetrators are set free, the potential to undermine the right to vote, it becomes a real threat to the voters themselves and ultimately Zambia's democracy. Prosecutors must approach electoral offenses as constitutional violations, because they are not merely statutory. They're interfering with the right to vote or the right to hold elective office, because they would target either the voter or the candidate. So effective trial advocacy requires adequate case preparation guided by the constituent elements of the offense. Prosecution of undue violence should also be contextualized within constitutional principles, so as to underscore the fact that prosecutors, now your role changes because you become sentinels of democracy. You carry this solemn duty of ensuring that elections remain free, fair, and credible. In terms of your cases which you bring, they must tell a coherent story. So the adjudication of electoral offenses will rely on, now this is on the part of courts, results transmission forms, ballot papers and seals, voter register, testimony from the ECZ. Because when you're preparing your case, and if there are any issues at all, when you're prosecuting any of these electoral offenses, ECZ now becomes your major source of testimony, because they are the manager of the elections. So when you're coming to court, you are coming with things that ECZ must be able to speak competently to. And in the case of Leonica and others, the Supreme Court held that electoral disputes succeed or fail on credible and verifiable evidence. And this principle, in my view, strongly influences criminal trials. I talked about authentication of documents, that these must be properly done. There must be shared claim of custody of documents. Witnesses, again, please avoid those who just come to say, I heard. Hearsay knowledge is quite unnecessary. Keep your witnesses to the minimum, and only those who can directly prove your case. The moral being that 10 poorly prepared witnesses weaken a case more than 2 well prepared ones. So rather you have 2 witnesses than 10, because your case might actually even be won on the first witness. One of the things that experienced defense counsel will challenge when they come before you or before us in courts is the legality of arrest or admissibility of documents. They'll say, and they will just know how to use these instruments against you. So from the bench, when we sit, we see that prosecutors must take charge and properly seal a case, and also anticipate what a properly deployed defense would look like. Look at all these elements when you're preparing a case. It's not just from the prosecution point of view, but also anticipate what could a good defense look like when we're preparing our cases. So why are we uncompromising when it comes to electoral matters? Firstly, because an electoral offense or election-related matter involves political rights. And depending on the outcome, a person could lose or win their elective seat, from the highest level of president going down to a councillor. So because of this, we are looking at the candidates who are involved in this election. It's very important that we look and see that the law presumes them to be innocent. But if the prosecution proves that they are not, then they must be held criminally responsible. So election trials, as I said, it involves candidates, party officials, campaign operatives, and I must say the people. Public pressure for conviction can be high. And because of that, we will ensure that the presumption of innocence is paramount in everything that we do. But most importantly, as you prosecute, allow the accused person to adequate time and facilities to prepare a defense, and also the right to a fair trial. All these are encompassing attributes which the court will not easily dispel because of the case or the person who is involved or the stakes that are there. Any perception of unfairness, where we notice that there's unfairness, courts will lead quickly acquit the person, or when the person has been convicted, may have a successful outcome on appeal. And this can lead to damage of institutional credibility of the prosecutors, because a conviction obtained unfairly is not a democratic victory. It is, in fact, a constitutional failure because you used all sorts of methods to reach your desired result. So, in terms of preparedness, what do we expect a prosecutorial services to demonstrate? This is institutional readiness. And here I must commend the Director of Public Prosecutions for hosting this workshop because it is so timely and gives you enough time to go back, reflect, and think on what you would develop as guidelines. So, in terms of institutional readiness, you'd be looking at things like case screening, identification of proper cases, weeding out weak or politically motivated complaints, preserving evidence. Cases would then be said to be competently prepared and prosecute, where investigations are professional, witnesses testify competently, evidence collection is lawful and documented, evidence is collection is lawful and documented. In short, poor coordination in the prosecution of a case is visible in cost and costly. We can tell when you have a poor case in court, but we have a duty to hear you. Whether your case has no merit or not, we will hear you. And at the end of the day, we'll just gladly tell you that we throw out this case because it had no merit. But also study the demeanor of judges in court, prosecutors. I've been one of you, so I never used to see those things. But now from where I sit, study me. If you see I've stopped writing, then you know that there are problems. Your case is not going far. So now, when we come to electoral offenses, and this is something that has been talked about, the elections now are no longer about what we knew them to be, physical violence or hate speech, character assassination. They are moving from that. They are now moved into the field of digital platforms. And I thought here that I should share a bit more to say that now elections are moving to misinformation, misinformation, and everything else. So vote buying arrangements, intimidation, misinformation, results manipulation, and illegal campaigns increasingly leave electronic footprints rather than physical ones. This is what is happening now. From a judicial perspective, computer-generated evidence is no longer exceptional. So in the next election, and this will be my third EDR cycle, and I would say that I would be competent enough to say that I have a lot of authority to say what I will say now, that we are now moving into an age of social media and digital platforms. But the reality is, how prepared are we, even as courts, to handle such evidence, which I think will become a factor in the 2026 general election. And on the other hand, how prepared are prosecutors to prosecute cases which involve digital platforms or social media? So the danger of digital evidence is that it's easily altered or fabricated. It's also highly technical, often misunderstood or poorly presented. Even I do not have that high technical competence in digital evidence or digital transmission of media, and I don't even have the language now. But the point being that this is where we are moving, and this is where we need to start thinking very seriously about how we're going to confront the problems, as they will come, and they will surely come in the 2026 general election. For prosecutors, it will mean that you may have your cases properly prosecuted or fatally weakened if you do not know how to process digital evidence and present it credibly before courts. Now, what constitutes computer-generated evidence in electoral offenses would be things which come from mobile phone data, such as SMSs, WhatsApp messages, social media posts, videos, and live streams, electronic voter registers and results transmission, CCTV footage from polling stations or campaign premises, metadata, geolocation data and timestamps, digital photographs, audio recording, and emails. All these things that I'm talking about are very difficult things for all of us, but we must find a way in which we try to understand these things. The reality is that if evidence is electronic in origin, it will be treated as computer generated, regardless of whether it is later printed on paper or not. Meaning that with us, we accept what comes in the original version that it does. So it's electronic evidence, meaning that it then becomes subjected to legislation such as the Electronic Communications and Transactions Act, number 4, 2021, and the Cybercrimes Act, number 4, 2025. So these are things that you must be aware of, familiarize yourselves with, how certification and requirements for electronic records is done, and there are quite a number of things. The distinction between primary digital evidence and secondary productions. And this is something that requires an expert, a role of expert testimony where interpretation is required. And I must emphasize this point. A prosecutor must never attempt to give expert evidence. Don't. Because you not only confuse the court, which is not an expert, but you also mess up the case entirely. Where expert testimony is required, get an expert, because that expert can explain how digital evidence was generated, stored, retrieved, and is likely, I use this in the positive, to persuade the court that it is reliable. Why is admissibility important? Because from the bench, it is the first judicial gatekeeper. Admissibility is the first battlefield. We look at that before the weight of evidence. Educators will immediately examine whether the device, now that's an electronic gadget, whether the device was operating properly, whether the data was produced in ordinary course of activity, that the system was not manipulated, the evidence is accompanied by proper certification, and the person tending the evidence is legally competent to do so. So what are the common errors? Producing screenshots without certification. That we will not accept. Relying on investigating officers to explain technical processes beyond their expertise, that the police officer comes and then tries to become an expert. Failing to link digital content to the accused person, tendering videos or audio without establishing authenticity, digital evidence that looks convincing but fails legal admissibility tests is worthless. What is the chain of custody and the principles to be applied, that the prosecutors will account for who accessed the device or data first, how data was extracted, whether forensic tools were used, the integrity of how it was preserved, where the data was stored, and who had access before trial. Our concern as judicial officers is unexplained access or casual handling of digital evidence raises a presumption of contamination. It's important to know that adjudicators do not convict based on digital activity alone. There must be clearly, that's the evidence, must be clearly connected to the statutory elements of such as the Electronic Communications and Transactions Act, the accused person, and within the relevant electoral period and jurisdiction. Again, you see the principles of how to prepare a case coming up. Now, to give you a practical example in terms of an electoral offense, an electoral offense is reported, and the source of data has been from WhatsApp, emails, videos, photos, social media, and electronic voter registers. So, in order to prove that offense, for example, a WhatsApp message must be linked to vote buying or intimidation, not mere political speech. So, in that WhatsApp, it must actually show that this is what was said, this is how it connects to the offense, and also this is how it connects to the accused. So, in terms of videos, we can't just take a video of a crowd. We must actually show where the video is taken, when, and how the offense was occurred. So general videos which are not showing you anything are of no help. Social media posts must be attributed to the accused person beyond mere profile ownership, because someone could create a profile on social media about you, say all these things when you did not say them at all. So it must go beyond what is on a profile. So it becomes a very high standard of how to apply digital evidence, but the point being that digital evidence proves nothing unless it proves the element of the offense. As I said, evidence would involve these other sources, which metadata analysis, results transmissions, server logs, digital manipulation, allegations, etc. The point being emphasized is that qualified expert witnesses should be brought and not witnesses who base their evidence on assumptions. And a word of caution is that courts become very cautious when prosecutors attempt to interpret technical data themselves, like using themselves. So you use experts who will explain these concepts and reports, because expert evidence clarifies facts, only clarifying facts. It never replaces them. Fair trial rights in digital evidence cases. Educators are particularly led to fair trial risks in digital prosecutions. So, in considering these cases, we expect full disclosure of digital material, access to devices or foreign images by the defense, adequate time for independent analysis, transparency in extraction methods, and digital efficiency and extraction methods. So digital efficiency must never override constitutional fairness. The use of computer-generated evidence is growing, and this should become, as I say, this will become a considerable issue in the next elections. Albeit fair trial rights, I cannot say more about this. That in our work, we always never forget the anthem that an accused person, according to our constitution, is presumed innocent. So let us not convict the accused person when we're preparing the case. That is for the court to do. Allow the defense to have adequate time to prepare the defense. Allow the accused to go through a process of a fair trial. And where they're using all sorts of devices or all sorts of sources of evidence, including digital, they must be accorded that opportunity when they're preparing their case to have access to that. And in an election cycle, the readiness will involve early case screening. So make sure that where cases are reported, you screen them early within your management system. You decide which cases the DPP will prosecute. That even when you're doing that at that early stage, there is credible evidence. Witnesses are protected. Professional investigations accompany each prosecution to be taken. And most importantly, coordination between investigators and prosecutors. And I'm sure those are things that you could have as a joint working session as you have done today. In concluding, I want to say that it's not about winning cases, but defending democracy when it comes to election cases. Your success in electoral cases should not only be measured by conviction rates, but whether justice has been done and has been seen to be done in accordance with the law. I stress that prosecutors as sentinels of democracy must strive to be independent, base their decisions to prosecute on real evidence given the emotive nature of elections, and most importantly, only bear fidelity to the law. After all, our mission collectively as election justice actors rests on upholding the rule of law and the integrity of elections. Success in electoral prosecutions is not measured by convictions. It is measured by justice done according to the law, protection of electoral integrity, and the defense of constitutional democracy. And as I conclude, I have a word of encouragement. I am one of you, having served as a prosecutor for a long time. I rose from the lowest rank of state advocate to heading departments. In all this, my greatest asset and pride has been serving in all the positions that I have worked with excellence, dedication, commitment, and energy. No job is and has never been too small for me. I pride my days from being a state advocate, and when I was at that point, I thought I owned the world, but little did I know that one day I would rise beyond. In so doing, I always show up as my ultimate best whenever I'm doing something, and I encourage you to also have that spirit. I know what it feels like to stand on either side of the bar and the bench. There's a lot of pressure on either side to deliver. And working in state chambers even puts more pressure on us personally and beyond. I am very proud that what has shaped me the most in my work career is what I learned from working in different departments in the state chambers over the years, and that I faithfully served in every position I was assigned. Remember, what you do as state advocates is very noble. And whether you see it or not, it is extremely rewarding because there's no better place to gain unparalleled legal experience than working in state chambers. I thank you. I can sit down. I sit down. What to say?
Ladies and gentlemen, as it were, the judgment has been delivered, covering all corners of the matters that were brought before the courts. Now, this is the time to have an opportunity to share in the judgment. We can interrogate or ask questions, comments are invited. The leadership is here for that. Any questions, please? If you have a question, you can raise your hand or an observation. I see a hand on the far end there.
Good afternoon. My name is Tinta Chimbali, public prosecutor. My question is, I see clarity when an MP, mayor, or councillor is undergoing trial for corrupt practice. Are they supposed to be in office, or they have to be suspended until the trial is concluded? I say so, putting in mind like the Livingstone Mayor case, she was still holding on to office until she was acquitted. So I would seek clarity on that. And my next question is on witness protection. How are these witnesses protected? I would like to know, because in Zambia, currently, I don't think witnesses are well protected, the whistleblowers. So, putting in mind the elections that are coming forth, what have we put in place for these witnesses to be protected? Thank you.
Thank you very much. So let me say that the Constitution is what provides for how elected officials are treated, because these are elected officials. So the Constitution is very clear to say that they can only vacate office if they are convicted. And again, when they are convicted and if they're given a non-custodial sentence, they can still continue in office. That's what the Constitution says. So as long as someone is undergoing trial and no judgment has been delivered, they will be presumed to be innocent. So in the case of the Livingstone mayor, I think after the final judgment, she was acquitted. So there's no process within the Constitution to remove an elected official who is facing criminal prosecution from office. What happens is that after the trial is concluded and judgment delivered, then that is when other provisions in the Constitution would be triggered to say whether that person continues in office or that person should vacate office. As for witness protection, I would yield this question to the Director of Public Prosecutions, because courts do not get involved. We only get involved when you bring cases to court. But to say that I'm not aware of the witness protection measures in Zambia, and I would agree with you that perhaps more needs to be done, but I would not be the competent person to answer something that is in the province of the Director of Public Prosecutions.
Thank you very much, my lady. Leonard, your comment?
Yeah. Prosecutor Chimbali, I think what I can say regarding, you used two terms. You used witness, then you said whistleblower. I think that we have a law that is supposed to protect whistleblowers, but obviously that law has quite some significant weaknesses in my considered opinion, and it's a law that we can strengthen further. We know that in certain jurisdictions, there are greater safeguards and mechanisms of protecting whistleblowers, which we do not have. We know that in certain jurisdictions, people even change identities. They're going to protected spaces. We do not have those type of resources in our country. So in that regard, yes, we have a few weaknesses. But when it comes to protecting witnesses that testify in court and maybe they face reprisals after that, we can do better again. I think we can all concede that we can do better. This is why in certain offenses, not just electoral offenses, even cases to do with homicides, we know that in certain instances, people just disappear. In fact, on a daily basis, we're dealing with cases where police often tell us that they cannot find witnesses. Using all available means, these witnesses will just have gone under. And we know that the problem is because they are fearing reprisals arising either out of the testimony they will give or if they've already testified before court. The issue here being that we have significant weaknesses in the legal regime, and we have to concede that that's a problem. In one province I heard of, someone was relaying to me that an entire village shifted because they did not want to be called as witnesses. Amazing. But that is because people are scared. Now, what is our response? Do we improve the law? Do we improve law enforcement? What can be done? I think now this is a subject of discussion and resolution of this convocation. I see my chief state advocate straight sitting directly to me. I don't know if she's able to supplement the last ceremony. It's up to you, but
thank you very much, Senator. Ms. Mumba.
Thank you, Lady Pipi and Mr. Bako for allowing me this opportunity. And thank you, Ms. Chimani, for the question. Yes, as the DPP has highlighted, we have challenges when it comes to witness protection, and especially when it comes to these election-related cases. It's been very, very difficult to secure attendance of witnesses. That's why the call is to have a collaborative approach with all stakeholders in the system. On a case-to-case basis, we've had incidences where some form of witness protection has been available to witnesses. I'm alive to some of the cases we prosecuted in Southern Province post-2016 elections. There were incidences of violence there. Because of collaboration with stakeholders, I have been stepped relocating some of the witnesses from that area. The victims were relocated to Mumbai. I think some of them may still be in Mumbai even up to now. At least that helped in ensuring their safety and their coming to court. Even when coming to court, we ensure that they were accompanied by officers at all times, even during their stay before they testified and after they testified. So even if we don't have witness protection guidelines or law in place, but on a case-to-case basis, something can still be done to ensure that witnesses are protected. Then other than going that route, I think in Hanet's presentation, she did highlight the need. One of the low-hanging fruits that we can utilize to protect our witnesses is to apply for simple things like having the case made in camera. I think my lady did mention that. That will also help in at least creating some form of protection to our witnesses during the trial process. But as the lady DPP has highlighted, we will take this as possibly a way forward in rallying for more support, aiming at protecting our witnesses. Thank you.
Thank you very much, Chief State Advocate Ms. Mumba. Any interventions, questions? I know the judge was very clear, but you may want to clarify something. Anything? All right. There being no further interventions, I do note that, my lady, you carefully loaded your presentation with very good, insightful items that moved from the courtroom up to the time judgment is made, from the prosecutor standing up to when the judge is looking at the prosecutor, and how we should be able to profile our courts as we appear before them. I'm happy, and I speak for myself and everyone here. I can see from their faces that we're extremely happy that we had this our first presentation. So, ladies and gentlemen, as we stand, her ladyship will be leaving us. I would request that we appreciate her with our clap as we acknowledge her being here. Let's stand. Thank you very much. Thank you very much. We may take our seats. By my watch, it is 12:54. So we'll go for lunch early and we'll come back early. We'll be back at 13:45 so that we continue with our deliberations or presentations, as it were. Now, for us to access this lunch, there will be coupons that will be given as we exit this building.